Good morning. My name is Beth Heel, and I'm the Director of HR Technology and Consulting for Diversified Employer Solutions Division. On behalf of Diversified Insurance Solutions and Paycor, one of our preferred HRIS HCM vendors, welcome to today's program that will discuss the basics that employers need to know about the Family and Medical Leave Act. Presenting today is Catherine Weber, an attorney and principal in the Cincinnati office of Jackson Lewis. Jackson Lewis was named the 2017 Employment Law Management Law Firm of the Year and ranked in the first tier nationally in the category of labor and employment litigation, as well as both employment law and labor law on behalf of management. Catherine is extremely knowledgeable in the area of FMLA and ADA. She advises and represents employers in a broad range of employment law matters arising under federal and state law. In addition to her counseling and litigation duties, Catherine frequently provides training seminars for employers on how to formulate and enforce effective personnel policies to avoid and minimize employee lawsuits. She has appeared numerous times on nationally syndicated radio talk shows, has published articles in state newsletters and magazines, and serves as chairman of the board of directors for the Employers Research Association, a Cincinnati-based organization providing companies in a 3-state area with HR advice, training, and updates on legal issues and HR consulting services. Please join me in welcoming Catherine Weber. All attendees will be placed on mute during today's webinar. Please feel free to type in your questions in the chat box, and Catherine will answer those at the end of the presentation. The PowerPoint presentation is attached in the handout section. As a reminder, we will be sending a recording of this presentation, the PowerPoint presentation, and any answers to questions that we may not be able to get to at the end of the presentation within the next 2 to 3 business days. So with that, Catherine.
All right. Thanks so much, and thank you, audience, for joining us today. We are going to be talking about the basics of Family Medical Leave Act. And as an added bonus, I want to make sure that we all understand that family medical leave is just the beginning when it comes to handling your leave management issues. So we'll also be comparing what the Family Medical Leave Act requires to what the Americans with Disabilities Act requires, so that you can get a full picture of what the requirements are with respect to both laws and get a complete picture of how you should be handling your leave management issues. Now, before we get started, I'm sure you're all thinking, you can't really be serious, Catherine. You have to have a disclaimer. Yes, we do. Well, it's just like the cup of hot coffee that you buy from McDonald's. You need a disclaimer with this PowerPoint that we're going to give you. It's very important that while you take in the concepts and you take in the rules that we're going to talk about today, with respect to each leave management situation that you have to deal with, it's important that when you get into grayer areas or trickier spots, that you reach out and make contact with the labor or employment attorney of your choice so that you can make sure that you're properly stepping through all of the necessary requirements in order to be in compliance with the law. Now, I had a wonderful introduction here getting started, so I'm going to quickly go through these screens and not hit everything, but I just want you to know that Jackson Lewis is a national labor and employment law boutique firm. All we do is labor and employment law. We do all aspects of labor and employment law all across the country. We have roughly 800 attorneys, and we're spread out across 56 locations nationwide. This puts us in a wonderful position to be able to give you that national talent, but yet deliver it on a local basis where we know who the attorneys are in the region, we know who the judges are in the state court, and we're able to combine that talent and that local expertise to get the best result possible. All right, so let's get started. First, let's talk about eligibility. Of course, that's where everything begins, and when it comes to the Family and Medical Leave Act, the very first thing you have to ask yourself is, am I covered by the Family Medical Leave Act? Well, in order for you to be covered, you have to have 50 employees total. And in order for an employee to be eligible for coverage, they have to be in a location where there are at least 50 employees within a 75-mile radius. When we compare that to the Americans with Disabilities Act, we see that the required number of employees before coverage kicks in is 15 employees, and those 15 employees can be anywhere within the United States. So there's a significant difference here between how many employees you have to have in order to be covered by the law. Again, under FMLA, it's 50 nationwide. With respect to the ADA, it's 15 nationwide. With respect to eligibility for a particular employee, they have to be in a place where there are at least 50 employees in a 75-mile radius. When we're talking about the ADA, there is no small site exception. If you've got 15 employees anywhere, you've got a potentially eligible employee. Now, a point worth noting here. Right now, we're talking about the Family Medical Leave Act and the ADA. Please be aware that some states have many FMLA laws and paid sick leave laws, and those laws may apply to employers who have fewer than 50 or more employees in a 75-mile radius. Similarly, with respect to the Americans with Disabilities Act, every state law has an anti-discrimination law that mirrors or is very close to the federal anti-discrimination laws. So you may have a set of circumstances where perhaps you don't have 15 employees nationwide, but you do have enough to trigger coverage under the particular state anti-discrimination law. And that could be as few as 2, 4, 6, or 8 employees, depending upon the state in which you're located. Let's talk now about length of service for eligibility. Under the Family and Medical Leave Act, first we have to make sure that the employee is in a location where there are at least 50 or more employees in a 75-mile radius, but that's not all. We also have to make sure that they've worked long enough for us in order to be eligible to take time off. Under Family and Medical Leave, they have to have worked for you for 12 months and 1,250 hours in the preceding 12 months leading up to the leave. Now, here's the tricky part. Most people don't know this, but that 12-month length of service, that doesn't necessarily have to be consecutive months of service. So you could have an employee who works for you in year 1, comes back in, works for you in year 3, and when we combine those months that they worked in year 1 and year 3, we get 12 months. If we reach 12 months that way, then we've met the 12-month requirement. Now, the ADA is very different. The ADA kicks in on day 1, hour 1, and it even kicks in for your applicants for employment. So for instance, let's take a situation where you just hired someone, we'll call her Sally. And Sally's only been with you for 4 hours. She goes out on her lunch break today and she gets in a tragic car accident that winds up leaving her in the hospital for the next 8 weeks. Under Family and Medical Leave, Sally wouldn't be eligible for family and medical leave even if she worked in a location that was large enough. But under the Americans with Disabilities Act, on the other hand, Sally would be covered. And you would have to consider whether or not Sally's condition rises to the level of a disability, and if so, whether or not there's a reasonable accommodation that you would be required to provide that wouldn't impose an undue hardship on you. Let's talk about the reasons for leave. Well, when we talk about reasons under Family and Medical Leave Act, what we're typically talking about is, does the employee have a serious health condition? When we're talking about the Americans with Disabilities Act, we're talking about whether or not the employee has a disability. It's important to keep in mind that most serious health conditions under Family and Medical Leave will probably be considered disabilities under the ADA. That also holds true for workers' comp injuries where the employee is absent from work for multiple days because of the underlying condition. Now, the ADA used to be far more employer-friendly, but back in 2008, that law was amended, and now there is a very high likelihood that the condition that takes someone off work, even for a short period of time, if the person is totally incapacitated, that would rise to the level of a disability. So let's get back to the Family and Medical Leave Act. When we're talking about a serious health condition, what we are talking about is certainly pregnancy, time off for pregnancy, the birth of a child in order to care for the child after the birth. We're talking about placement of a child for adoption or foster care. We're talking about serious health conditions in the way of inpatient care. So if someone spends the night in the hospital, an overnight stay, that would be considered a serious health condition. We're also talking about conditions that require continuing treatment by a healthcare provider. And under the heading of continuing treatment, what we're typically looking for is incapacity of 3 or more days plus treatment twice by a healthcare provider in 30 days, or once plus a continuing regime of treatment. And that might mean something as simple as I went to the doctor and I got a prescription for an antibiotic and I was absent from work and incapable of performing some essential function of my job for more than 3 days. It will also include, serious health conditions will also include chronic conditions and permanent or long-term conditions where treatment is ongoing but not necessarily active. It can also include conditions that require multiple treatments for restorative surgery after an accident or an injury or a condition that, if not treated, would result in 3 or more days of incapacity. So under family and medical leave is available when the employee has a serious health condition. It's also available when the employee's family member has a serious health condition. So when we talk about family members under FMLA, we're talking about a spouse, a parent, or a son or a daughter. Under the Americans with Disabilities Act, although it applies when an employee has a disabling condition, it does not apply when a family member has a disability. What about pregnancy? Certainly pregnancy is covered as a serious health condition under the Family and Medical Leave Act, but under the ADA, it gets a little bit more gray. A normal, regular pregnancy under the ADA is not considered a disability. However, to the extent that the pregnant employee suffers from some pregnancy-related medical condition, and that condition would otherwise rise to the level of a disabling condition, then we've got coverage. You should know that the EEOC has pregnancy discrimination high on its list of priorities this year, and they are actively seeking out charges where they will litigate against employers who they believe have engaged in pregnancy discrimination and ADA discrimination involving a pregnant employee who has an underlying medical condition related to the pregnancy. What about time off work for the birth or placement of a child? Under the Family and Medical Leave Act, yes, the employee is entitled to time off for the birth or the placement of a child. Under the Americans with Disabilities Act, though, the employee is only entitled to time off work to the extent the doctor indicates that the employee is unable to work due to recovery from the birth of the child. So, for instance, let's take Sally again, and let's say she wasn't in a horrible accident, but 6 months after she begins working from you, she gives birth. Well, certainly Sally hasn't been with you long enough to be FMLA eligible because she hasn't been there 12 months and 1,250 hours. But when we look at the ADA, if Sally's doctor says Sally is unable to work for 8 weeks following her pregnancy, then that would be considered a disability under the ADA, and you would have to seek to provide a reasonable accommodation that doesn't provide or that doesn't impose an undue hardship on you. And that can take the form of many things. In this particular instance, most often the form that it would take would be unpaid time off work. What about qualified exigencies? Under the Family and Medical Leave Act, that law covers not only serious health conditions, but it also qualifies and applies to military family leave. And under the heading of military family leave, if an employee has a situation which we refer to a qualifying exigency, they can get 12 weeks off work. Now, what am I talking about? Well, let's go back to Sally. Let's assume that Sally tells you that her husband has been called up for duty and he is going to ship out in 1 month. About all of the things that Sally and her family might have to take care of before her spouse ships out for duty. Those things we would consider as qualifying exigencies. So they would kick in for things like arranging for childcare, arranging for meetings with teachers at the school, arranging for meetings with your banker, or maybe meeting with your attorney to make sure that your estate planning documents are in order. Maybe there's some counseling that the family needs to go through in anticipation of Sally's spouse shipping out. Maybe Sally's husband gets to come home after he's shipped out, and he gets to come home for a period of 3 days. Certainly that period of rest and recuperation where the family is going to be with where Sally's going to be with the family, that might be considered a qualifying exigency as well. So when we're talking about qualifying exigencies, we're talking about all those things that might go along with the need for time off work to take care when a family member is getting ready to ship off for duty. And when we talk about family members, remember we're talking about a spouse, a child, or a parent. Now, under the Family and Medical Leave Act, under the military family leave portion, there is also a provision that allows employees to take up to 26 weeks off work to care for a wounded family service member. Okay, and again, that's 26 weeks, and that would apply if Sally has her spouse, her son, her daughter, her parent, or her next of kin that needs care because of an injury that that family member suffered while in active service. What about under the ADA? Or is there such a beast such as qualified exigencies or time off to care for wounded family members under the ADA? The answer is no, there's not. All right, let's move on to alcoholism. How is alcoholism treated under Family and Medical Leave? Well, under Family and Medical Leave Act, alcoholism could be considered a serious health condition. It could also be considered a disability under the ADA. However, employers are permitted to hold current users of alcohol to the same standards as everyone else. So for instance, if you have a rule that says everybody has to be at work on a timely basis and they have to work the full day and not leave early and not come to work late without prior notice and approval from their manager, but you have someone who suffers from alcoholism and they're frequently late for work, they're frequently absent, you can hold that employee to the same standards that apply to everyone else. Now, if that employee, and let's say it's Sally again, comes to you and says, I need to take time off work because I am going to enroll myself in this inpatient care treatment program at the local hospital. Could that be considered as a serious health condition that would entitle Sally to the time off work in order to get that care? Yes, it would. All right, let's move on to drugs. So for current illegal drug use, that's not considered a serious health condition, but treatment for substance abuse is considered a serious health condition. Under the ADA, if the person is no longer using the drugs and is participating in or participated in a rehab program, then that person might get protection under the ADA. This is a challenging area of the law, particularly with respect to the opioid addiction problem that we see throughout our country. If you run into this situation where you have someone who needs time off work or perhaps has engaged in some misconduct and immediately says, oh, it was because I'm addicted to heroin, you need to reach out to your employment attorney to work through that process and make sure you get to the right answer. It's pretty simple if the employee doesn't ask for time off work to undergo rehab, but it gets a little trickier when in fact they ask for time off work in order to recover. All right. We've now talked about the reasons why somebody might be able to take time off work under the Family and Medical Leave Act, and we've talked about the reasons why someone might get time off work as a reasonable accommodation under the ADA. Let's now talk about how long they get to take off work. Under Family and Medical Leave, it's 12 weeks, unless it's a situation where the employee is asking for time off work to care for a wounded service member. In that case, it's 26 weeks. Under the ADA, this is a challenge for folks because there's no bright line limit as to how much time off work an employer might be required to provide as a reasonable accommodation under the law. And some very well-meaning employers have employment practices and policies that say we'll provide people up to 6 months off work or 1 year off work, but if you can't return at the end of that 6-month period, your employment will be terminated. You need to know that if you have a bright line rule like that, living in your policies and your practices, and the EEOC finds that, the EEOC will come after you with the full force of the agency. They will come after you not only with respect to the employee that perhaps filed the charge, but also they could come after you on a systemic basis because the EEOC takes the position that employers should not have bright line policies, but instead they should consider each request for time off work under the ADA under its own unique set of circumstances. So you could very well have a situation where one employee is able to receive 6 months off work under the ADA as a reasonable accommodation, and another employee might have 9, and another employee might have 8. I know that's counterintuitive to the way that we typically think about avoiding and minimizing the risks for discrimination. We always talk about we want to be consistent and we want to follow the same rules. But when it comes to the ADA, we have to be very, very conscious of not applying bright line rules like that to our employees. Otherwise, we could run afoul of the law. All right. Let's talk about intermittent and reduced schedule leave. Now, I know that intermittent and reduced schedule leave is the thing that drives every HR professional crazy when it comes time to trying to manage that time off work and to planning for those absences. And, you know, unfortunately, intermittent and reduced schedule leave, it's here to stay. It's not going away. And if you think about it, it's for a good reason. So think about it this way. If you have somebody who suffers from a serious health condition, let's say it's a chronic condition, maybe it's Crohn's, maybe it's multiple sclerosis. Those are the types of conditions that may have flare-ups. So it's possible that somebody could go months without a flare-up, but then when they have a flare-up, they might need to take half a day off because of the flare-up, or they might need to take 2 full days off because of the flare-up, or perhaps they're only able to work half days for the 2 weeks after a flare-up so that they can get back up on their feet. You can understand when you put it in that perspective why intermittent and reduced schedule leave can be a good thing from a policy perspective, but like every law, most people, the grand majority of people, the law is in place and they use it for good reason. There are, however, a handful of folks who do not use it for good reason and they try and take advantage of it. And those are the folks that we really need to manage and try to put in rules and practices that will reduce that type of unfair advantage taking, if you will, by folks who perhaps have a bad case of Monday, Friday-itis or holiday-itis and not necessarily a need for intermittent and reduced schedule leave under the FMLA. All right, let's talk about under the ADA. A lot of employers think that under the ADA, they only are required to consider requests for blocks of time off work as a reasonable accommodation. Unfortunately, according to the EEOC, that is not so. However, the good news is even the EEOC will acknowledge that regular and predictable attendance is an essential function of many jobs. So if you have a situation where, let's take the person who has Crohn's disease, and that person has the need for time off work due to flare-ups. Certainly, you would be required to provide the time off work for the flare-ups and for medical appointments associated with the need to manage the condition. However, if the flare-ups and the time off work get to be such that they're so unpredictable and they're so frequent and sporadic that they start to impose an undue hardship on that employee's team or that employee's department, then you can look for an alternate position that better suits that employee's need for time off work. That doesn't mean that we fire the person. It means that we look for a vacant position that better suits their need for time off work. Now, of course, if there is no better position that suits their needs for time off work, then we can talk about what are the necessary steps and whether or not ending the employment relationship is appropriate. But you at least need to go through that process to see what other types of accommodation might be appropriate in order to help that employee be able to perform the essential functions of their job. All right. Under the Family and Medical Leave Act, the next question is, how do we respond to a request for time off work? Can we request medical certification or something from the doctor saying that, yes, Sally has a serious health condition and she needs time off work? Under Family and Medical Leave, yes, you can do that at the beginning of the leave, and you can do that annually each year. Under the ADA, you can certainly request that type of information to establish that the person has a disability and that the person needs an accommodation. You can also request medical certification if the employee poses a direct threat of immediate harm to himself or others. But in that situation, and in fact in all situations where we're requesting medical information for a current employee, we have to make sure that our need and our request for medical information is job related and consistent with business necessity. All right, let's move on to the next question. Under the Family and Medical Leave Act, can an employer offer another accommodation instead of leave? So you have to keep in mind that under the Family and Medical Leave Act, when a doctor fills out the form, all he has to do is find that the employee is unable to perform one singular function, essential function of the job in order for that employee to be suffering from a serious health condition and therefore eligible for family and medical leave. I know that's a surprise to people. Most people think, oh, they can't, they have to have a condition such that prevents them from being able to perform the job altogether. That's not the case. When that happens, though, can you offer the employee, hey, Sally, I understand that, your doctor has indicated that you need family and medical leave for this period because you're not able to perform the essential function of lifting. If I could transfer you to another position, Sally, would you be interested in that position so that you wouldn't have to take family and medical leave? Under the FMLA, you can absolutely make that offer to Sally. However, if Sally says no, you can't attempt to convince Sally to continue to work. If Sally wants to take her FMLA, Sally is entitled to her FMLA. What about under the ADA? Let's take the same set of circumstances. The doctor says Sally is unable to perform lifting and lifting is an essential function of her job. Can I say, okay, doctor, well, you say that Sally needs time off work as a reasonable accommodation under the ADA, but if lifting is the only thing that she can't do, perhaps I'll allow her to use a forklift. Perhaps I could transfer her to a different position. Perhaps I could have other employees in the area assist her when she can't lift more than X pounds. All those things are possible under the ADA, and you can require them because Sally doesn't get the accommodation of her choice. You can provide her an alternative accommodation as long as it's effective. That, again, is very different than under the FMLA. Let's talk about second opinion. So Sally brings you in a doctor's note and you read that note and you go, no way, I just don't believe this. This isn't possible. So can you get a second opinion? Well, I like to say, the joke, the employment law joke is, second opinions are a lot like Christmas. They only come once a year. So you can ask for a second opinion, but only in response to that initial certification that comes in from the treating healthcare provider, and then once each family medical leave year. So it's really, really important that when you get the completed certificate of healthcare provider form back from the treating physician and you read it, make sure that you scour it, because if you miss the opportunity to seek a second opinion, that opportunity will not come around to you and for another year. All right, let's talk about under the ADA. Can you get a second opinion if I get something back from the doctor? And again, this assumes that the FMLA doesn't apply, either because Sally hasn't worked there long enough, or you're not large enough to be covered, or maybe she's exhausted all of her family medical leave. Let's say I get that note back from the doctor and I don't believe it. Can I get a second opinion? Sure you can. Absolutely. So in that regard, the ADA actually has far less obligations on employers than the FMLA. So yes, you may get that second opinion. What about recertifications from the healthcare provider? Well, under family and medical leave, there are very, very specific rules regarding when you can seek a recertification from a healthcare provider. Under FMLA, you can ask for recertification every 30 days unless the certificate says that the employee's condition will last for longer. If that's the case, let's say Sally's doctor says that she has Crohn's or she has MS, and this condition will be lifetime. Then obviously you don't have a situation where it's very different than if the doctor says she's got this condition and it will last for 3 weeks. When the doctor says it will last for 3 weeks, you can ask for recertification if she asks for more time off work, or better yet, even a new certification form. But in those circumstances where the doctor says the condition will last for more than 30 days, then the every 30 days rule doesn't apply. When we get into situations like, for instance, Crohn's and multiple sclerosis, other types of indefinite conditions that will last for a lifetime, then you can ask for recertification every 6 months. There are exceptions to the 30-day and the 6-month rule, and those come into play in the following circumstances. One, if Sally asks for more time off work than what the doctor already certified her for. Two, if the circumstances described by the certification have changed in some way. Or three, if there's reason to doubt the validity of Sally's request for time off work or her absences from work. And there's a very particular manner that you go about seeking recertification under this exception to the rule. So what you would do, let's say that Sally has told you that she has MS, and I apologize for picking on MS and Crohn's, but those are two conditions that we often see. Sometimes it might be migraines or maybe it's irritable bowel. So we could use any of these conditions that go on indefinitely. But let's say that Sally comes to us and says, look, I've got Crohn's and it's a lifetime condition, and my doctor has completed this form and he says that I'm likely going to need probably 2 half days off a month. All right, or maybe he says she's probably going to need 2 full days off a month because of flare-ups. Now, let's say during the summer months, you get into a pattern where Sally is asking for every Friday and Monday off around a holiday. You know, if you think about it, during the summer season, there's almost a holiday a month. So if we get into that situation where we have someone who we think is taking advantage and perhaps taking more time off, not because they really need it for their health condition, but because they want to spend time, on the weekend, having a long weekend, then what we would do is we would prepare a letter for the treating physician, and we would say, Doctor, enclosed is a copy of the certification of healthcare provider form that you prepared for Sally. In the form, you said that she'd need 2 days off a month. Here is the list of all the days that she has taken off under family and medical leave for the past 3 months, and then we would list them, and we would show it as Monday, Friday, Monday, Friday, Monday, holiday, Friday. And we would make sure that we would lay it out very specifically for the doctor. And then at the end, you would say, Doctor, we need to know whether or not Sally's recent pattern of need for time off work is consistent with the certificate of healthcare provider that form that you completed and returned to us. And if not, then we need a new certification. In those circumstances, many times the doctors will say whatever it is that Sally wants them to say. I get that. But sometimes, and yes, I have had this happen, the doctor will write back and say, absolutely not. Sally shouldn't need that much time off work. And if, in fact, her condition has deteriorated to the point where she thinks that she needs to miss that kind of time off work, then she needs to make an appointment to come back and see me so that I can recertify her. Now, what that does for you is two things. Number one, if the doctor says, no way, she's scamming you, wonderful. Now you can tell Sally, nope, that's not appropriate. Here's your certificate of healthcare provider form, and here's what I expect on a going forward basis. But even in the circumstances where the doctor backs Sally up and says, oh, no, yeah, I think that's appropriate, that's consistent with the certificate of healthcare provider form that I previously provided, at least now Sally knows that you're not going to stand for abuse of your leave policies, and hopefully that will make Sally more cognizant and more conscientious about using her family medical leave. Now, under the ADA, what do you do? Can you ask for recertification from a healthcare provider when somebody is taking time off work as a reasonable accommodation under the ADA? Yes, you can, as long as your request is job-related and consistent with business necessity. Let's talk about whether or not you can move Sally to a different position. So let's say she does have Crohn's and she's absent a lot and it's frequent and it's sporadic. Unfortunately, under family and medical leave, you can only transfer the employee to a different position if the leave is foreseeable based on planned medical treatments for the employee or a family member. It can only be a temporary transfer, and it has to be with equivalent pay and benefits. Now, let's think about this. Clearly, the folks in Washington who set up the parameters of this law and who set the rules this way didn't get it, because we as HR professionals and legal professionals know that the type of absence that is the most challenging to deal with is the one that's unforeseeable. It's the one where Sally needs to take time off work and she never knows when it's going to be, and it's frequent and it's sporadic and it's for flare-ups, not planned medical treatment. If it's for planned medical treatment, she can tell you that she has an appointment on the first day of every month or the 15th day of every month from now for the next, however long it is. That type of absence you can plan for and staff for. It's that unplanned absence, that unforeseeable absence that is more challenging for you, and it's the one that you wish you could transfer Sally on, but you can't, at least not while she's under family medical leave. Now, when we get under the ADA, so once Sally has exhausted all of her time off work under FMLA, and we're only covered by ADA, then yes, if it becomes an undue hardship to keep Sally in her original position, then we can transfer her to a vacant position that better meets her need for time off work. And what if that other position is one that pays less or differently? Well, we just have to pay her consistent with what that other position would pay. All right, let's talk about benefits. So with respect to health insurance benefits, under family and medical leave, Sally gets to keep whatever her health insurance was that was in place prior to the time that she began her leave, as long as she's continuing to pay her portion of the premium. What about under the ADA? Under the ADA, you really have to look at what your insurance policy says. And this is a big deal, and it's something that's frequently missed by employers. And although it rarely lands the employer in hot water, when it does, it essentially puts the employer in the place of being the insurer. Here's the way it goes. So when you fill out your application to get your group health insurance benefits, there's typically a portion in the application where you can make changes or request changes. And certainly in your summary plan description and in your policy, there will be a provision that talks about who is eligible for group health insurance. And it will say, in most cases, that in order to be eligible for group health care benefits, an employee must work on average X number of hours per week, or be on family medical leave. That's the general way that we see the language. If that's the way your policy reads, then if someone isn't under family and medical leave and they're taking blocks of time off work, maybe they're off work for 3 months as a reasonable accommodation in order to recover or to take chemotherapy treatments and radiation and recover from cancer. In that circumstance, if the person's not under family and medical leave and you're accommodating under the ADA and they're not regularly working whatever the minimum number of hours per week as set forth in the group health insurance policy, can you continue to provide that person with group health insurance? The answer is no. You can't, because you can't extend benefits that you contractually aren't eligible to extend to that person. The person's not working the required minimum number of hours per week, so there's no eligibility. Now, sometimes policies say that the person has to work X number of hours a week on a regular basis, or be on family and medical leave, or be on an employer-approved leave of absence for no longer than X period of time. That last phrase, we call that a Good Samaritan clause. And that Good Samaritan clause allows you to extend, to continue to offer health insurance benefits to somebody without placing that person on COBRA if they're not under FMLA. So you need to make sure, as part of your leave management practices, that you check and see how your policy is worded. So let's talk about returning from work. With someone that's under family and medical leave, what kind of position do they return to? Well, they return to the same position or an equivalent position. Under the ADA, they return to the same position unless you've reached the point where it's an undue hardship on you to continue to keep the position vacant while the person is on leave of absence, in which case you can fill the job. And if you filled the job and the person says, okay, I'm now ready to come back to work, that's fine. Then you look for a vacant position that fits their skill set and abilities. And if there is one, great, you consider them for it. If there's not, then you can end the relationship at that point. What about fitness for duty upon return to work? Well, under the FMLA, if you indicated in the designation form that they're going to be required, essentially, the doctor will be required to certify that they're able to perform the essential functions. You check that box, then yes, you can require the doctor to say that the person is able to perform the essential functions of the job. You can't get a second or third opinion on that, okay? Under the ADA, you can require that the employee provide a letter from the doctor indicating that the person is able to safely return to work and perform the essential functions of the job without posing a risk of harm to themselves or someone else. All right, so we went over that what constitutes a serious health condition rather briefly when we looked at the chart. Let's look at it again. We're talking about an overnight stay in a hospital. That's an immediate trigger. Absence plus treatment, there we're talking about more than 3 days plus treatment twice or treatment once plus a regime of continuing treatment. Any period of time off work for pregnancy, any period of time off work for chronic conditions, permanent long-term conditions, or situations where someone needs multiple treatments for non-chronic conditions that would become chronic conditions if you didn't allow the treatment. It would be so easy if employees had to use magic words or specific words to ask for FMLA, but they don't. So you need to make sure that you and the folks on the front line are cognizant of and aware of what might trigger a need for you to potentially say, hey, employee, Sally, you may be entitled to family and medical leave. Here's a certificate of healthcare provider form. Please have your doctor complete it and return it to me. So what might be those kind of triggers? When somebody says, I've got to have time off work to a surgery or a hospitalization. If someone says, I'm pregnant and I'm suffering from terrible morning sickness and I have these prenatal visits, all those things would be triggers for FMLA. If the person has frequent absences or tardiness that's due to an employee's or a family member's health issues, again, that could be a trigger for FMLA. Absences related to a family member's call-up, that could be FMLA under the military family leave features. And anytime you've got somebody who's got a health-related absence that lasts more than 3 calendar days, there should be an automatic trigger, and all your managers should know that. When you're administering FMLA, we have to administer it with precision, but we have to be respectful. We want to curb abuses, but we don't want to discourage people from exercising their FMLA rights. And we always want to be professional and respectful, and we want to avoid any conversation that might be hostile or appear as though you're frustrated, because that will only come back to harm you, and it will also make your relationship with the person who needs your help very strained. So what should you be doing? Well, first, you should be auditing your policies. If you want to stay in compliance, the first place you stop is you take a look at your policy. Does your FMLA policy include all the required elements? Does it say, who is, whether or not you're covered? Does it say that employees have to work at a work site where there are 50 or more employees in a 75-mile radius? How do you define what is considered that 12-month period? We say that employees can take up to 12 weeks off work during any 12-month period. Well, you get to choose how you measure that 12-month period. Are you doing it in a way that's the most advantageous for you, or are you doing it in a way that's the most advantageous for the employees? Most employers who've taken some time to consider this will say, look, I'm going to use a 12-month period, a rolling 12-month period, measured backwards from the time that leave was last used. So that way we don't get into a situation that you would find yourself in if you're using a calendar year. So let's take an example. So let's say Sally says, I need time off work for back surgery October, November, and December. And let's say you use a calendar year. Well, in that case, Sally can take October, November, December, and she can also take January, February, March. That would be a bad thing. Instead, if you used a rolling 12-month period, that wouldn't happen. Sally would only get essentially that 3 months off work, and she wouldn't come back into eligibility until she had reached the point where those 3 months had fallen off. Does your FMLA policy inform employees that merely saying they're sick is not enough? I know they don't have to use magic words, but you need to make clear that they need to tell you more than I'm out sick today, because if they don't do that and you don't tell them that they need to do that, then you're going to have a big problem when it comes to managing leaves. Have you looked at your attendance and call-off policies? Okay, if you have an attendance call-off policy that says employees who won't be able to come to work in a timely fashion have to contact their manager at least an hour before, and you have somebody that it's an intermittent leave taker and they start violating the 1 hour call-off rule, well, that 1 hour call-off rule can be used on the intermittent leave taker so long as it isn't a situation where the employee would be able to show that it was impractical or impossible for them to give you that kind of advance notice. So it's important that you have those advanced call-off features in your attendance policy. All right. If you're looking at your attendance policy, one other thing that you need to do is you need to make sure that if you've got one of those policies where employees accrue points for absences, make sure that you've got a sentence in there that says that points don't accrue for time off work under the FMLA or ADA or other company-approved leaves of absence. That's something that your employees probably will blow right past. They won't understand the meaning of, but the EEOC will, and it is a shield that you can use to protect yourself from an aggressive EEOC investigator who wants to take a single charge systemic. Do you have a reasonable accommodation policy? If you don't, you need one. All right. That reasonable accommodation policy is pretty simple. It's only a paragraph or two, and it essentially says that, look, we comply with the ADA, and if you need a reasonable accommodation, let us know. Reasonable accommodation can take many forms, and maybe it gives examples. It tells them also who to contact for that reason. What do your policies say when FMLA is not available? Do you say that, employees who can't return to work within after their FMLA expired will be terminated? If that's what you say, the EEOC will probably put a target on your back. On the other hand, if you keep in mind that FMLA is the beginning and not the end, and you have some sort of a feature in there that allows an employee to flip over essentially or transition over to some sort of an extended leave of absence, you're way, way further ahead in this process. Again, remember, you don't want an extended leave of absence policy that includes caps or bright lines. You want to make clear in the policy that we don't have a bright line rule as to how much an employee can take off work. Instead, we view each circumstance on its own unique set of facts. Now, certainly that doesn't mean you have to give open-ended or indefinite leaves of absence, and we build that into the policy too, but we just want to make sure that we don't, again, make ourselves a target for the EEOC. The next thing that you need to be doing to make sure that you're in compliance is grab a handful of let's say you take 10 random FMLA taker forms and look at those forms. Did the employee provide reasons for an absence that sufficiently triggered FMLA rights? I mean, did they really check the boxes so that the person it's clear that they have a serious health condition? Did you issue your WH-381 form timely. You know, when an employee says, hey, I need time off work because I'm pregnant and I'm going to deliver, you know, on such and such day, or I need time off work because I'm going to have this surgery. You have 5 business days after receiving notice of that need for leave to issue this form to them, and it's a Notice of Eligibility and Rights and Responsibilities form. You can find it on the Department of Labor's website, and it is WH-381. It's a pretty simple form, and it's a wonderful thing to use. You don't have to use that particular form. You can use your own, but we recommend that you use the form that's available through the DOL. All right, so let's say that you got that right. You're randomly sampling your leave taker files, and you did issue the Notice of Eligibility and Rights and Responsibilities within 5 business days. What about when you got the information back from the healthcare provider, that Certificate of Healthcare Provider form that the doctor fills out and returns to you? Well, you're supposed to, within 5 business days of receiving all the necessary medical information, issue a determination, either designating the time off work as FMLA or not, and that's called the Form WH-382. Again, that's a form that is available on the DOL website. Now, when you're looking at those leave taker audit files, you need to take a peek at what happened when you got information or when you had to reach out and get additional information from the healthcare provider. Did you seek only the information you were entitled to seek, or did you seek too much? When you said, I need clarification or authentication of this completed Certificate of Healthcare Provider form, were you within the bounds of the FMLA, or did you go a little too far? If you asked for clarification or authentication, did you explain why you needed it? Did you include a GINA safe harbor clause on your forms and in your cover letter? All those things are things that you should be doing in order to protect yourself from FMLA claims and ultimately from systemic claims by the EEOC or class claims based on private attorneys. Also take a look at those medical certification forms and ask yourselves, wow, when they came in, was that form complete? Was it sufficient? Did it set forth the anticipated frequency and duration of the episodes of incapacity for somebody who was going to need intermittent time off work? And did you follow up when you had the opportunity under the law to do so? All these things will give you an idea of whether or not you've got shortcomings in your policies and practices that you need to address now before they become a problem later. Now, the last thing that you need to do is review those FMLA, those leave taker forms, those files, and see what happened to your employees who said at the end of their FMLA, I'm not able to come back to work because my back condition hasn't healed to the point where I'm able to come back to work. I need more time off. Look at those files and see what you did. If you immediately terminated employment, that's an issue. You need to be talking to your labor and employment attorney regarding these types of things and making sure that you're not talking amongst yourself in-house. Talk only to your labor and employment attorney about what you see here. Better practice is even to have your labor and employment attorney work with you to conduct the audit. But in the end, we have to keep in mind that FMLA is just the beginning. It's not the end. So in the circumstance where Sally says, I took all my 12 weeks of family and medical leave and I need an additional 4 weeks off in order to continue my treatment and recovery, under ADA, Sally might very well be entitled to that time off work under the ADA. So you've got to make sure that you're handling the FMLA properly and then transitioning over to the ADA again so that you don't find yourself in the future in a bad situation with the EEOC or in a lawsuit on, that was brought by a private attorney for one person or maybe for a whole group. So these are all the things that you can do in order to help yourself in terms of managing leaves of absence and ensuring that you're in compliance with the FMLA and the ADA. And at this point, we're happy to take any questions that you might have.
Catherine, we do have a question for you, and the question is, how is diabetes handled under FMLA? Can that employee take intermittent leave any day they don't feel good and can't come into work?
So with respect to diabetes, diabetes is probably going to be considered a serious health condition under the Family and Medical Leave Act, and so you would issue your notice of, if the person's eligible, of course, you would issue your notice of rights, you would get your completed certificate of health care provider form, and then you would look at what the doctor says regarding how much time off work the employee will need based on the condition. Then you just need to follow what the doctor says with respect to how frequently the person will need time off. Unfortunately, diabetes may be one of those situations where the employee has flare-ups and maybe can't predict when they'll feel so bad that they'll be unable to come to work. But again, you just revert back to what the Certificate of Healthcare Provider form says. If you get into a situation where the pattern of absences isn't consistent with the form, then we can move into the situation where you can contact the doctor and say, hey, here's the pattern, here's your form. Let us know if the pattern is consistent with what you thought it would be.
At this time, Catherine, we don't have any other questions. So on behalf of Paycor and Diversified Insurance Solutions, thank you very much for presenting today. And as a reminder, the PowerPoint presentation and the recording will be sent out in the next day or so to all participants. Thank you for joining and have a good rest of the day.